Hi, this is Numan along with my group members. First of all, I would like to discuss the overview of this case. This case scenario discusses the damages that can be claimed by the plaintiff due to the negligence of defendant party. The plaintiff in this case is Sonja Horne. Horne got into an accident on her way from school to tennis center. The school had an activity to practice tennis at Coops Tennis Center. The safe travel arrangements were the responsibilities of school administration. The plaintiff was traveling from school to tennis center on a bicycle, which was big and difficult for the age group of plaintiff. The bicycle was not in the ownership of plaintiff, which reveals that she had no practice in riding bicycle on Bean Road. It was her first time to ride bicycle, which was borrowed from her friend. The brakes of bicycle were not working properly. The plaintiff knew the fact that brakes of bicycle were not good enough to control the bicycle. The road had downhill portion, which makes it difficult for bicycle riders to control. The plaintiff, while riding the bicycle, knew the fact, but despite knowing the fact, she continued to ride the bicycle. She fell. She fell in front of semi-trailer after a collision with the bicycle of her friend. She got injured and now at the age of 23, she is claiming for damages from the state of Queensland. The gracious care provided by her mother and brother to her during the years between 1985 and 1990, the rate claimed is $15 per hour. The plaintiff also claimed to provide commercial assistance as she will go through three further operations between the age of 30 and 65. The court has to decide after listening to the arguments of both the parties to the contract the right to complain compensation for damages incurred to an injured person and her need for attendance of care services were recognized by the High Court of Australia in Griffith versus Kekember 1977 HCA 45. The court decided that whether the injuries have created the need for commercial assistance or for domestic work. She is unable to perform due to injuries of accident. The plaintiff is entitled to claim and recover the compensation for the services, whether they are provided by graciously or commercially. And secondly, the parties involved in this case is that in every legal lawsuit, whether law or criminal, there are two parties involved. The party suing is the plaintiff, and the party against whom the lawsuit is carried out is called the defendant. In some situations, more than one plaintiff and or defendant may be involved. Here, in this case, the state of Queensland is being sued by Vita Sonja Harne. The case scenario makes the state of Queensland is defendant and the Sonja Harne is plaintiff. The case scenario consists of other two defendants, Lyle Norman Butcher and Finney Burris Transport Private Limited, the driver and the owner of semi-trailer. These two defendants are not guilty of any negligence on. And secondly, the general principles of duties and negligence involved in this case is that all the individuals owe a duty of due care to other individuals. The duty involves not to hurt another person as a result of his or her negligence and act of omissions. There are certain special reasons which give rise to special responsibilities between the two parties. For example, the relationship between school administration and their students. At school premises and activities, it is the obligation of school authorities to take care of children from any kind of physical injuries. The extent of liability of school authorities is yet to be decided. It varies from case to case, and the argument presented in the case of law of how the accident has happened and who was the responsible for the accident. To present the case better in the court of law, the argument and reasons presented in defense should be logical enough to sustain in debate. The lucid presentation of argument and evidence is the key to court-winning debate. Crafting an argument, stating your argument early and clearly, and organizing your paper around the argument is essential to successfully defend a negligence claim on a part of state Queensland. The argument presented should be: my first argument is that children were allowed to go to tennis center from school. Many students walked by foot to tennis center from school. This shows routine activity of school. The applicant used the bicycle which she borrowed from her friend to ride from school, and the route she selected all by herself was the most heavy trafficked and dangerous for the children of that age group. The road was dangerous for the children of her age group. The school administration has no role in making the decision of riding the bicycle. Even she had no practice of that selected route she selected. She didn't her her own bicycle.
Hello everyone, my name is Mohammed Asnan and I will start the rest of the assignment which we have done, and I will start from argument 2 from where my brother Noman left. The argument too about this corporate law assignment says that the Beams Road is heavily trafficked and dangerous for children. The road has some downhill portion which makes it hard to ride and control the bicycle for the children of that age. Appellant knew that despite it, she continued to ride the bicycle. She was amateur in riding bicycle on Beam Road. It was her excitementful decision she took all by herself which leads to their accident. So it means we are making her responsible for that because he never cared about herself. She should be careful about riding and bicycle on the road. So we are actually making her accountable as well. She fell into front of the Femi trailer on a downhill portion of the Beams Road. She fell after her bicycle got in contact with the bicycle of her friend. The mistake which leads to the accident is not the fault of school administration. The decision taken by an amateur girl to ride bicycle on traffic route was the cause of the accident. The argument 3 is there was also evidence that the bicycle appeared to be too big for the plaintiff and this may have contributed to her loss of control of the bicycle in the downhill portion of Beams Road. Contributory negligence on the part of the plaintiff needs to be taken in the mind. The plaintiff has certain obligation to take care of. So it means the actually the bicycle became very big enough for the plaintiff, and that's where the accident occurred. Argument 4 is the brakes of the bicycle the plaintiff was riding were defective. In fact, the words used by the plaintiff herself weren't that good. It gives us the idea that she knew that the brakes are not good enough to control the bicycle on a downhill portion on a heavily traffic route, and also known the fact that she decided to ride on that. So the one issue is the brakes are not too good of the bicycle as well, that caused the accident as well. And argument 5 is the first question to be asked in entitlement. Does the appellant actually needed the assistance of her mother and brother? And if the assistance was needed, then how much assistance was needed? What is the medical evidence to support the claim? The plaintiff claimed that the carriage use domestic assistance provided by her mother was for 6 to 7 hours, and domestic assistance provided by her brother was 2 to 7 hours. To determine the market value of the care which the mother and brother provide to her, the domestic assistance provided to the plaintiff by her mother and the brother is rated a very high price. The document, the rate claimed is $15 per hour. Assistance provided is of domestic nature. The rate consists of administrative costs which are not allowed in credit use assistance provided. The rate needs to be lower than the claim rate. Though law allows to claim damages, but the three hold set by law should be satisfied. The letter from a commercial care provider, for example, dummy care, is not enough evidence to state the list of duties and rates of payment charged by the plaintiff, mother, and brother. The argument 6 said the established duty of care between the plaintiff and the defendant is duty of plaintiff to prove that defendant should have foreseen the result of their negligence. This is not enough to claim that the defendant knew about the consequences of the negligence. Certain cases have been decided which needs to be studied to better understand the content of duty of school mission in foreseeing the risk of accident. Argument 7 says that in preceding court has overturned the decision to award commercial assistance as the calculations were based on the medical assistance banning immediately after the assessment of the damages. Though the plaintiff was receiving the gratuitous assistance from her brother and mother, there is no reason to believe that it will stop in future. The evidence that the plaintiff will have 3 hip replacement and 1 knee joint replacement operation between the ages of 30 and 65 and that these operations are necessary due to accident. Argument 8 says that the evidence that states the assistance was essential as the medical condition of the plaintiff were severe and assistance was needed. The evidence of the nature of the injuries and the impact of the injuries on the activities of the plaintiff. Now the arguments which we have done in this assignment have been completed by my part, and now we'll go to the conclusion of the case. The conclusion of the case is that after analyzing the case study and synchronizing the arguments presented, the decision reached is that there was a negligence on the part of the school authorities. The court may apportion the basically the negligence of the court may apportion the damages in percentage. The 75% damages on the offended is not adequate a portion of the damages. The rate claimed by the mother and brother is inadequate. The damages should be around $5 per hour. But before reaching the decision, the precedents and provision of the law needs to be scrutinized. So that was the assignment. That was my part. My name is, which has been ended. My name is Muhammad Asnain, and my student ID is FAH2182. And thank you so much.